Julius Joho.
On the strength of that mere piece of paper. That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are 2 subtitles at page 60 of that manual, which is subtitle 1, Comply with Court Orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is Participate Actively in Court Proceedings, and this Senate has communicated to us through this manual that ignoring court orders against the county assembly or the Senate is not the solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist, because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly before the new Constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the governor's documents. It is found in volume number 4 of the governor's documents, and you'll find that ruling starting at page 165 of volume number 4 of the governor's documents. But the relevant part I will refer to in the interest of time is at page 168 of that volume, volume number 4 of the governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I will then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the 3rd paragraph. Although I have read that this court decision does not stop the National